order. I'd like to welcome everyone to this hearing of the Committee on Ways and Means. As you all know, there's only one bill on the agenda. It is Senate Bill number 2272, filed by Senator Sonny Angara. Just as a very quick background on this issue, which is really just for the record because all of you already know this. We are hearing this bill because of all the questions, confusion, clarifications that a lot of our stakeholders want. And for the record, I started receiving some of your messages, letters, emails, concerns, of course, through various senators a few months ago. But as you know, we were in this committee was very much involved in other tax measures. And so I had made it known to all that we will have to deal with this after we pass the current tax measure. So that is the reason. And I do believe that my staff has communicated that with all of you. No? So it was really just the desire of this representation to handle things in a more logical and cohesive manner, other than me just giving you quick answers that won't resolve anything. And then Senator Sonny Angara filed the bill, so I felt like, well, then we might as well hear it, which then gives all of you your opportunity to raise your concerns. So again, as a quick backgrounder, we were looking at two provisions of this bill. Senator Sonny had, I think, submitted in writing one version, and then there was a lengthy discussion on the floor with Senator Recto. And in the end, it was the version of Senator Recto that was carried by the body. So many of you are lawyers, so I'm sure you've done your homework and tried to understand what the intention was here. But all I'm saying now is that it was very clear that what we carried is an existing provision of the bill with a simple change in the rates. So that's what happened. No? So I won't go into anything further, but just to clarify, like, what did we change? We just changed the rates of the existing provision. So on that note, we can now proceed. I will call the government agencies first. Let's see. Government agencies, so just to run through them, that would be DOF and BIR, the most significant. DepEd actually doesn't have a representative because they said that this being a tax measure, they do not have anything to add. But CHED has a representative. I don't know what they intend to add. But yes, I will call you, Senator Drilon, after I see you. And was there anyone else? Okay, I see you. Just also ask my...
With all due respect, before we call on the agencies, Madam Chair, can I be allowed to make an opening statement before the source persons will speak?
My staff informed me of that, and I was going to call you first, so don't worry. I'll just run through. And any other senator who would like
Madam
to make
Chair?
a statement. Sunny, of course, it's your bill.
Yeah, can we sponsor the bill at some point?
Yeah. Okay. So if Senator Gilon, if it's okay with you, I'll call on the sponsor first, no? Senator Sonny.
Sure.
And then you, and then I saw Amy raising her hand. Joel.
Madam Chair, yes.
Did I miss anyone? Because there are other what do you call this? Some of the other senators might be on the other, but I don't think I missed anyone. Okay, but before I call the senators, I'm just running through the agencies. So those are the most important agencies. I don't know really what CHED and TESDA have to say, but so you don't have to take the floor unless you have something to say about this issue. It's important lang that you know what's going on. And then we will go to the education institution, and this is where makikiusap ako sa inyo. No, we have the umbrella organizations such as Cocopeya, PACU, and the like. And if your concerns are already addressed here, then please note that your position papers are duly noted, and we will share this with all the senators. So you do not have to read it. But if you want to share your views, may I remind all, which is a rule I have, huwag nyo na kaming basahan kasi pwede naman kami magbasa, and that's what the umbrella agencies are there for, not to cover the whole ideas. Just feel free to express your sentiments about it. Pero wag niyo na kaming basahan. And then let's limit that time because medyo nagulat lang kasi ako that there are regional representatives and let's honor naman everyone's time. No? That's why I just want to still give you that time if you want to. You don't have to because your mother organizations will be given sufficient time and your position papers are just as the strength of your positions papers are just as strong as any statement. So it helps us if we just have key people speaking. Okay, so yun, pag binasahan niyo ako, rest assured, I will interject ha. Sasabihin ko talaga na kung babasahin niyo lang yung buong paper, basahin na lang namin. Okay? I just really want to be more organized here, everyone, kasi ang dami nung gustong magsalita. Okay, so as I said, let me call on Senator Angara for his opening statement, sponsorship, and then Senator Gilon, and Senator Joel and Senator Aimee were the ones that I saw. I will rely then after this on the Secretariat to tell me who else. Otherwise, kung wala nang ibang senator, then we will go to DOF. All right, so I give the floor to Senator Angara.
Thank you, Madam Chair. Good afternoon to our colleagues and to all the government agencies represented and the education stakeholders present. At the outset, I'd like to thank our chairperson for acting so swiftly on this bill, given the urgency, the issue. Thank you, Madam Chair, and thank you for your initial remarks, valuing the time of each and every one of us here. I'll try to do the same and keep it brief. It's a very simple bill, ma'am. It's Your Honors, it just seeks to amend Section 27B or clarify Section 27B of the NIRC, National Internal Revenue Code, which to change the wording, to make it, to clarify that proprietary educational institutions should be taxed at a lower rate of 10%, which is the provision that has been in our statute books for almost 50 years, if I'm not mistaken, Madam Chair. And we had to do this because there are varying interpretations by some of our revenue authorities. But I also must state that we should thank DOF Secretary for publicly stating, Sonny Dominguez, DOF Secretary Dominguez, for publicly stating that he supports the amendment of the tax code to this effect, given that he has worked previously with the Ateneo de Davao, and he realizes that these are very difficult times for our educational institutions, Madam Chair. So any higher tax imposition is not only unwarranted in law, it's also very bad policy, Madam Chair, given the history of our educational reforms. The private education sector was hit hard by the K-12 law back in 2011, 2012, but yet they supported it given its strategic importance to making Philippine education very competitive globally and to make graduates of senior high school employable even without a college degree. We're still working on that, of course, as you know. And secondly, the free college or the UACTEA law also hit the private education sector hard. That was the second big blow. They lost a lot of students to that. And this would really be the, sabi nga natin, baka strike 3 na to for our private education institutions, Madam Chair, given the difficult straits they face. And of course, strike 4 would be the COVID pandemic. So pag pinagsama-sama po lahat yan, it is a very difficult period for our private educational institutions. So I think this is a very urgent measure. And again, we reiterate our utmost gratitude to you, Madam Chair, who is one of the primary advocates. You're the senior vice chair of the finance committee in charge of the educational institutions. So you know very much how they are facing difficult straits or struggles at present. And we try to do our best by providing for vouchers, expansion of the ESC, the service contracting, and the GASPE. But of course, you know, to jump from 10 to 25%, wow, that could be the final nail in the coffin for many of the smaller private schools, Madam Chair. So yun lang po, it's a very simple bill. So to give way to the others, we won't do any extended. Allow me, Madam Chair, to mention that many of our colleagues have signified their wish to co-author the bill, and I'd like to thank them I'd like to name them individually: Senate President Pro Tem Ralph Recto, Senator Majority Leader Zubiri, Senators Gordon, Villanueva, Gatchalian, Poe, Binay, Pangilinan, Hontiveros, Pacquiao, Revilla, and Villar. And I know Senators Marcos and the Minority Leader are also very supportive of this bill, Madam Chair. They've made statements to that effect, if I'm not mistaken. So thank you, Madam Chair, and thank you, dear colleagues.
Thank you, Senator Sani, for that. Let me now give the floor to Senator Gilon. Yes, Senator Risa, I'll call you after. I acknowledged from my staff that Senator Risa had made a reservation before I called on the others. After Senator Gilon, Senator Risa, when you're ready.
Thank you very much, Madam Chair. I will try to be very brief. Madam Chairperson, you know, this, as you have seen in the recent past, senators both from the majority and the minority blocs have complained about how an implementing rule or regulation supposedly to implement the law have actually gone beyond what the law is and sometimes even contradicts the spirit of the law. And this bill that your committee is now hearing, Senate Bill 2272, seeks to correct that patently erroneous interpretation of the tax regime governing educational institutions. This is a classic example of this revenue regulation, is a classic example of why the senators are complaining about the implementing rules and regulations. As you correctly said, Madam Chairperson, the Create Bill did not touch upon the characterization, the character of the educational institution. It did not. We did not touch on it. It's the same. What we did was to touch on the rates given the pandemic, the effects of the pandemic on the educational institution. Let me repeat that. We did not amend the characterization or the coverage of educational institutions or the definition. We only touched upon but the BIR regulation, Madam Chairperson, ruled and interpreted it otherwise and redefined what is an educational institution for purposes of the tax regime that would be applicable to them. And because of this totally uncalled for interpretation, Senator Angara has rightfully filed a Senate Bill 2272 and supported by a number of our colleagues. Madam Chair, let me add my support to this measure. How I wish the BIR will simply correct the BIR. I wish the Department of Finance will simply correct the interpretation of the BIR. BIR is under the control and supervision, so that we do not have to go through all of this process of hearing it in committee and debating it on the floor. And having said that, Madam Chair, I am certain that BIR Regulation 2027 will be 2021, 5-2021, will be questioned before the courts as being beyond the scope of the Bureau of Internal Revenue to implement in the manner that they want to implement it. That is why this bill is being proposed. We realize, however, Madam Chair, that this is a bill and would need the concurrence of the House of Representatives. And since it's a bill, it will need the approval of the President. We do not know what will happen. That is why it is in this context, Madam Chair, that should the committee file a report favorably endorsing this bill, I would strongly suggest that accompanying that committee report recommending the approval of this bill would be a resolution which will put on record the interpretation of the Senate, the interpretation of the deliberations in plenary, insofar as the bill is insofar as the create bill is concerned. To me, that is essential, ma'am, because remember that we are already on our last on our last year. We have just practically a few months of substantive legislative work, and we do not know how the House of Representatives, how the President will react to this bill. It is for this reason that we are proposing a resolution accompanying the committee report, so that we can put on record the intention of the Senate on this measure, so that it can assist the courts in interpreting the legislative intent when we pass the create. That is my suggestion, Madam Chair, which I hope that the committee can consider favorably, so that it is clear from the legislature, from the Senate at least, what we intended to do, or what we intended insofar as this measure is concerned. Thank you very much, Madam Chair.
Thank you to the Minority Floor Leader. Just a quick comment on His Honor's statement. He started, about saying how there have been many confusing statements or interpretations from BIR. And when I also mentioned in my opening statement about the need to prioritize, so we were finishing other tax measures, behind the scenes, and some of you know this, I was working with DOF on a weekly basis on various interpretations also of so many other bills. And that is, I would think the reason why I ended up hearing this bill is, number one, this was the only issue of the many issues in create that had some issues, conflicting interpretations. This is the only one that there was a bill filed to clarify. And after spending so much time going back and forth with DOF and BIR, it really was the simplest thing for me to do, because honestly, this is like the fifth issue that I've been dealing with since the passage of create to further clarify BIR issuances that seem to be contradictory, or at least not consistent with the, in fact, hindi pa nga spirit of the create law, but the clear wordings of the create law. So that is the reason why it's just easier also for me to just have this hearing. And I thank His Honor Senator Angara for just making it easier. Otherwise, I would continually still be going back and forth to this day. Anyway,
we have suggested a resolution in order that in case this bill does not become law, at least on record is the official interpretation of the Senate insofar as this particular provision is concerned. That's all we intend. That's all the only intention of our proposal, Madam Chair.
Okay, thank you. So if Senator Riza is ready, we can call on her now. Are you ready, Senator Riza? Yes, okay, proceed. You have the floor.
Thank you, Madam Chair. Madam Chair, my dear colleagues, our dear resource persons, magandang hapon po. Madam Chair, I was happy to add my name as co-author of Sen. Sonny's Senate Bill number 2272. And I was even happier to note that at least 9 other colleagues also co-authored the measure. It would appear that the legislative will is to support this measure and to rally behind our schools and educational institutions. Pero, Madam Chair, napipinto na po ang pagbukas ng academic year 2021 to 2022. Kaya urgent ang panawagan na pansamantalang isuspinde ang Revenue Regulation 5-2021. The danger of schools closing down and cutting costs on facilities, teachers, and technological infrastructure, as well as passing on the tax burden to enrolled students, is imminent if we do not suspend RR 5-2021. Ako po'y solo mom na nagtustos ng pag-aaral ng 4 kong anak from grade school to college. Alam ko po ang hirap ng pagbayad ng tuition fee at na-imagine ko na lalong mahirap sa panahon ng pandemya. Ang aking pangamba ay kung ganyan kataas ang buwis na ipapataw sa mga schools, ipapass on ito sa mga magulang na nakukuba na sa mga gastusin ng pang-araw-araw. Therefore, in closing my brief opening manifestation, Madam Chair, just to reiterate my support for the passage of Senate Bill 2272, hopefully in the short term, but also the temporary suspension of Revenue Regulation 5-2021 in the immediate as an urgent action. Salamat po, Madam Chair.
Thank you, Senator Riza. Let me call on Senator Joel. He has a meeting and I promised him he'll have time to deliver his sponsorship or whatever statement he needs to make. Go ahead, please.
Thank you, Madam Chair. Una po sa lahat ay magandang hapon. Good afternoon to all our colleagues, Senator Risa, Senator Frank, Senator Sani, Senator Aimee. And of course, we would like to commend our hardworking chair of the Committee on Ways and Means, Senator Pia Cayetano, sa mabilis na pag-aksyon dito po sa napapanahon at napakahalagang usapin na ito. Alam nyo, hindi mahirap maghagilap ng datos na magpapatunay na kritikal ang papel na ginagampanan ng ating mga private education institutions sa iba't ibang antas ng edukasyon at sa buong Pilipinas, no? At yan yung dahilan kung bakit bilang chair ng Higher and Technical Education, mabilis ho tayong sumuporta dito sa ipinanukala ni Senator Sani Angara. Alam niyo, sa antos ng kolehiyo, 53% ng 6.18 million na Pilipino na nakapagtapos ng kurso ay produkto ng mga private universities and colleges. Halos ganito rin nga po pag tinignan nyo yung textbook sector. Dahil 4,001 out of 4,439 na TVET providers, or you're talking about 90.23% ay mga pribadong institusyon. Sa basic education level naman po, isa sa kada 5 mag-aaral ay enrolled sa private schools. Bagamat mas mababang porsyento ang sinasalo ng private schools in terms of absolute figures, the total is as high as 4.3 million students enrolled in private basic education schools nationwide. So, Madam Chair, with these figures, our point is clear and simple. Private schools are partners of the state in carrying out the duty of educating our young people. Alternatively, Madam Chair, anything that threatens the viability of private schools affects the future of our children. The pandemic has increased the cost of education, including the cost of internet connectivity, equipment for flexible learning, and forced schools to find solutions to foster quality teaching amidst these trying times. Yung NEDA po has pointed out that education sector ranks second in terms of the total number of jobs lost due to COVID-19 pandemic. Buong taon na po silang nakadapa, kaliwat kanan yung pagtatanggal ng mga empleyado nila dahil mahigit 1 taon na pong sarado ang mga eskwelahan. It is for these reasons, Madam Chair, that we support Senate Bill number 2272, which seeks to guarantee that all private educational institutions, whether non-profit or stock or for profit, can avail of the preferential or special corporate income tax, which is at 1% from July 1, 2020 to June 30 of 2023. Banggitin ko lang po, Madam Chair, yung ilang datos din mula sa CHED kasi noong October 2019, bago pa man po tumama yung pandemya, 10.49% increase ang average na pagtaas ng tuition fees sa academic year 2019 to 2020. Kasama rin po dito yung 12.55% increase sa other fees. Sa memorandum po ngayon na nilabas ng CHED, May of 2021, ang inaprubahan po na pagtaas na tuition 2020-21 ay 12.06%. Hindi po ito gaanong mataas nung kumpara doon sa nakaraang taon. Pero kung titignan po natin yung pagtaas naman ng other fees, ay 30.39% o higit sa doble noong pong bago ang pandemya. Kaya nga po, gaya ng marami sa atin, sa Senado, Madam Chair, kung yung mga sigarilyo, alak at iba pang gumagawa ng sin products, binaba po natin ng gusto yung corporate income tax nila sa Create. Bakit po tila dodoblehin ng BIR yung pong taxes para naman sa mga paaralan? So again, Madam Chair, let me end by saying it is clear that we have to help rather than increase the burden of over 14,435 private basic education institutions, 1,729 private universities and colleges, 4,001 private TVIs in the country, which may be unduly affected by the illogical increase in their corporate income tax. I also would like to spread into the records that I join and support the call of our minority leader to pass a resolution and to again point out that Senate is clear with our intention noong pinasahon natin yung Create at hindi kasama dito ito pong mga paaralan na maaapektuhan ngayon. We're again calling the BIR to revoke itong Revenue Regulation 5/2021 at kailangan po talaga ng pribadong paaralan ng agarang pag-aksyon sa issue na ito. Kaya muli, maraming salamat, Madam Chair, for this opportunity at sa ating mga kasamahan sa Senado. God bless us all. Salamat po.
Thank you, Senator Villanueva. Senator Marcos, you're next.
Yes, thank you very much, Madam Chair. And as usual, Senator Sani Angara simply beat me to the quick and filed the bill ahead of me. And for that reason, I'd like to extend my wholehearted and unqualified support for his bill. Certainly, it was never the intention of either House of Congress to deprive the already beleaguered education sector of their well-deserved reduction in tax or the 10%. So I'd like to be made a co-author officially. And further also, as described by Senator Drilon, our outstanding minority leader, following the Supreme Court decision of Commissioner of Internal Revenue versus Bicolandia Drug, where it is settled that there should be no regulation in conflict with the law that it implements. May I urge that the chairwoman also take similar notice of the bill I recently filed, number 2306, also to do with the IRR of Section 309 in the Internal Revenue Code, referring to work from home and limiting thus to 30% of the workload for export-oriented BPOs and call centers. Given that these BPOs and export-oriented industries are one of the few green shoots of the post-COVID economy, I am hopeful that I will get similar support from my colleagues. Thank you very much, Madam Chair.
Thank you. Idagdag ko sa listahan ko yan. Marami yan. Anyway, Senator Pangilinan, you have the floor.
Yes, thank you. Just very briefly, we likewise manifested our desire to be co-author of this measure filed by Senator Angara. We believe precisely that this, the non-resolution of this issue is really creating so much difficulties and so much uncertainty on the part of our education sector. And the sooner we are able to resolve this, the better, especially at this time. I share with the I would like to associate myself with the manifestation as well of this our minority leader, that pending the final approval of this measure and prior to before it becomes law, we should likewise consider the adoption of a resolution so that the intent of the Senate and Congress in terms of the 10% and tax rate is made clear. Considering that, of course, all tax measures will have to emanate from the House, the Senate can only go so far. But I think a resolution in the meantime would likewise bolster the position taken by the private sector and, of course, the Senate in terms of ensuring that the erroneous interpretation by the BIR is set aside. Thank you, Madam Chairperson, and maraming salamat.
Okay. Senator Drilon, Senator Gordon, I acknowledge your presence. Would you like to make a statement? Go
Yes, I'd
ahead.
like, thank you very much. I'm sorry I was delayed. I had a speech to make before the United Architects of the Philippines, and I cut it short for this. It's a very important measure that we've all co-authored, and I said support of the entire Senate. And I'd just like to point out that it's very, very clear that our Constitution and several provisions of the law of the Constitution clearly states its priority for education as a matter of state policy. And certainly, it also specifically states not only the Declaration of State Principles that the state shall give priority, but also insofar as education science in Article 14, it says constitutional provision assigning the highest budgetary priority to the education center. You may assign the highest budgetary priority, but you take it back when you provide incentives and you take it back. And what happens? There's double talk, constitutional double talk on the part of the executive. And then finally, there's also the tax privilege status given to schools. And it even cites under Section 4 of paragraph Article 6, Article 14, rather, Education, Science, and Technology. It says under 4.3, proprietary educational institutions, including those cooperatively owned, may likewise be entitled to such exemption, subject to the limitations provided by law, including restrictions on dividends and provisions for reinvestment. So everything under the Constitution points that we must support education, and rightfully so, justifiably so, because we are a country that has fallen back in education, and that education is the key to human development and certainly will uplift our people out of and free them from poverty. And poverty is an absence of choice. And if you're not properly educated, your choices are fundamentally limited and restricted. In addition to this, Mr. President, CREATE was created. Although I voted against it, I was the only one who voted against it and spoke against it. I feel duty bound now to speak out because, the object of generally of the law I thought was good. And however, it's just instances when I begin to really grouse over what is happening to our country. We make laws in this Congress, in the Senate, and then when it goes down to the executive, they take liberties. This is not the first time, Mr. President. The fundamental problem with our country is that there is no enforcement of law. And the law is interpreted by people who are not in Congress. They try to make laws when they're supposed to be enforcers of the law. And what has happened here again is a classic example, like in the tourism law. They chose not to give the incentives. We provided incentives in many places and they take it out. The government give it and the government take it. So, ano yan? Politika? Pinopolitika ito? It really is dismaying and certainly disappointing, if not exacerbate, if not at the very least, makes you feel that there is that our ship of state is floating from here and there, depending on who has the last ear, who gets to the president as the last voice in the ear of the president. So, Mr. President, insofar as this is concerned, we all know that CREATE was there to provide incentives during this very, very severe crisis that we're facing to businessmen, including schools, especially schools. So why are we now getting back and saying that they should be taxed? They should not be available. The proprietary schools should not be, be given the 1% that is being given to all the other schools. And why should we now bring them back to 25% when they were already paying 10%? And in the midst of the crisis, not only here, but when we switched to K-12, a lot of teachers have lost their jobs. When we promoted the salaries of public schools to higher salaries than private schools, the private schools have been marginalized. Many of the public school teachers came from the private schools. And so there will be no development in our private school system in terms of new buildings, new teachers, especially when you take out this provision that is supposed to incentivize the private school system and all the schools for that matter generally, and certainly private schools which include colleges, tech-voc institutions, and members of an organization called Cocopia, which has 4,125 members covering 6.1 million students. These are the people that will be affected. No, sir. they are the ones impacted by this tsunami, but eventually it will be a tsunami to our country because we will have less students getting schooled in private and in public institutions, Mr. President. On that note, I rest my case, Mr. President. I will participate, and I thank you for giving me the opportunity to speak up on this very, very important matter that I feel very, very strongly and passionately about. We must protect the schools. We must protect the children. We must protect the teachers, and we must be true to our word. Acta non verba. Thank you.
Thank you, Senator Gordon. So with no other senators who would like to take the floor at this point, we can proceed with our resource persons. Like I said earlier, we'll start with DOF. And the representative of DOF is ASEC Dakila Napao. And after that, please be ready, BIR. So ASEC, please, you have the floor.
Thank you, Madam Chairman. Good afternoon, Madam Chairman, and to the honorable members of the Committee on Ways and Means of the Senate, and to all resource persons for joining this meeting or hearing. Madam Chairman, the DOF is not against the proposed measure, which aim to subject all proprietary educational institutions to the reduced preferential rate of 10%, which is now 1% until June 2023, by removing the qualifier non-profit or proprietary educational institutions in Section 27B of the tax code as amended. Private non-stock non-profit educational institutions falling under Section 27B and private stock for-profit educational institutions will now be both subject to the 10% preferential rate under Section 27B of the tax code, provided that the 50% threshold on gross income is satisfied, Madam Chair. So that's all for our opening statement, Madam Chairman. Thank you very much.
Okay, thank you. Thank you for that brief statement. Anyway, we'll open the floor later on to senators who have questions, but let's try to go through the resource persons now. BIR, let me call on ASEC Larry Barcelo. And then after that, is there anyone from the educational institution who want to make a statement or observer na lang kayo? Just let me know. Thank you. Go ahead, BIR. ASEC, who is this ASEC? Assistant Commissioner.
Good afternoon, Madam Chair. Good afternoon to the members of the Honorable Committee, your fellow resource persons. The BIR, like the DOF, Your Honor.
Medyo hindi ganun ko clear yung ano nyo yung audio nyo. It's a little bit parang sabog.
Sorry,
That seems better. Maybe the mic was just far from you.
the BIR also supports the passage of this bill, Your Honor, as it will once and for all clarify the coverage of Section 27B. The Commissioner already expressed his support to this bill. And we have our meeting with the Committee on Ways and Means of the lower house, Your Honor. That will be all, Your Honor. Thank you.
Okay, thank you. Are there any educational institutions, I mean the government educational DepEd, CHED, TESDA who need to make a statement now? Kasi kung hindi naman, then observe lang kayo and see kasi technically naman it's out of your hands. So let me then proceed with the other speakers. Let me call now on Attorney Joseph Noel Estrada, the Managing Director of Cocopea. We'll give some time limits here. No? Like I said, marami kayo eh. So si Cocopea, of course, being one of the major umbrella organizations, we'll give you more time. So you have about 5 minutes plus one extra in case kulang pa yung time.
Thank you.
Go ahead.
Thank you, Madam Senator. Good afternoon. Good afternoon po, and good afternoon to all our members of the committee. and to the officials, government officials here present, and my colleagues from the private education sector, those who are joining us this afternoon on WebEx and also via the social media platforms. First of all, we would like to express our gratitude to the chair of the Senate Ways and Means for organizing this forum, very timely, and also to thank
Hearing to, hindi forum, hearing.
sorry, the hearing of the Senate and Ways and Means Committee, and also to thank Senator Sani Angara for filing Senate Bill 2272, and all the others who manifested their intention to co-author the bill. And on behalf of the COCOPEA, we'd like also to express our full support for the approval and the passage of Senate Bill 2272 to finally preserve the spirit of the CREATE insofar as the preferential tax treatment of proprietary educational institutions consistent with the constitutional provision, Article 14, Section 4, Paragraph 3. And for us, historically, it has always been this way. I think we would like to emphasize that with the passage of this bill or enactment of this bill into a law, this will not start a new tax regime for us, because for us, it has always been this way. Historically, since 1968, preferential tax treatment has always been given to proprietary education institutions. And this is actually recognized and confirmed and affirmed by the Constitution under the 1887 Constitution under Article 14. So this is not something new for us. Doon po kasi sa kanina na binanggit from the DOF to finally change the tax regime and remove that non-profit requirement. But for us, it has always been clear the non-profit qualification pertains only to hospitals, not to proprietary education institutions. Now, setting aside the legal discussions, Madam Chair, would like to highlight the urgency of the intervention of the legislature on this problem on our tax treatment because of the pandemic, as already reported by different government agencies on education. We are the hardest hit, one of the hardest hit sectors. Around 900,000 students in private basic education were not able to re-enroll last year, and around 400,000 students were not able to re-enroll and have transferred to the public education system. And 900 schools closed. So we're looking at this trend to continue without the government economic and policy intervention. With the support of the senators this afternoon, it's really very encouraging for us to continue. And we of course appeal for recognition of the private education sector in our contribution to our rehabilitation and recovery measures post-pandemic, and certainly our contribution in the human capital development and our contribution to the labor force should be also given some weight in all of these recovery measures of the government. Your Honor, we are here present, and also we have school heads and tax experts, and we're ready to answer any question from the committee chair and the members. We also submitted the position paper to suggest some wordings on the Senate Bill 2272 to further strengthen it, and as to leave no more doubt as to the interpretation and the preferential tax treatment of proprietary education institutions. Magandang hapon po ulit at maraming salamat po.
Thank you very much for that. Let me now call on PACU, Philippine Association of Colleges and Universities, Attorney Ada Abad, my schoolmate actually. Hello, Ada. Go ahead.
My schoolmate
Magandang hapon,
too.
Senator P. Hello. Magandang hapon po. I'm deferring to our President, Anthony Tamayo, if you please, kasi they prepared the statements for us. Maraming salamat for this.
Senator Pangilinan was also acknowledging na nakikiclassmate siya sa'yo.
Oo nga eh. Bye-bye. Hello.
Okay, so Attorney Tamayo,
Yeah,
you have the floor.
thank you. Good afternoon, Honorable Chairperson of the Ways and Means Committee, Senator Pia S. Cayetano, and honorable senators and members present. On behalf of the Philippine Association of Colleges and Universities and the COCOPEA, I would like to express our full support for the urgent approval and passage of Senate Bill 2272, entitled an Act amending 27 of the National Internal Revenue Code as amended and for other purposes. We profoundly thank Senator Sani Angara for immediately filing SB 2272 and to all the honorable senators who have agreed to co-author and support it, and to finally clarify the grant of preferential tax treatment to proprietary educational institutions consistent with the Constitution and the CREATE Act. Private schools have been a major contributors to new investments in the education sector needed for it to become competitive. In light of the major new investments needed to transition to the new normal and to combat the national learning crisis exacerbated by the pandemic, the preferential tax treatment of proprietary educational institutions is indeed necessary to spur further investment and enhance the complementary role of private education or the private education sector under the Philippine education system. On the other hand, the erroneous provision of RR 5 2020 will add an additional heavy burden to many of our stakeholders in the private education sector at a time when we are already fighting for our survival amidst the pandemic. Many of our people will be directly affected by these government policies, including our different scholars, academic, athletic, working, athletes, and even the staff.
Last 1 minute.
Even members of our communities and the ecosystem, the carinderias, bookstores, will also be affected, even our faculty development and innovation and other activities. So with all these, we'd like to thank the Senate for hearing us, and I hope the immediate passage of the bill will be granted. And we'd like to thank you again, Senator Pia, for giving us this opportunity to participate in the deliberation of SB 2272, and we hope for the swift and urgent passage of this measure, and finally clear the preferential treatment of the consistent with the Constitution and the law. And indeed, a lifeline for us to survive during this pandemic. Mabuhay po kayong lahat and stay safe.
Thank you for that. Senator Villar, you're raising your hand.
Yung isang stakeholder, kababayan ko si Anthony Tamayo. Kaya I'm here to manifest my co-authorship of the Senate Bill 2272 of Senator Angara. Thank you very much.
Thank you. My understanding is the two organizations that spoke are umbrella organizations. I think many of the other, if not all of the others, fall one way or another under your organizations. Is that correct, Attorney Estrada and Attorney Ada Abad? Anyway, I'm just asking because, like I said, I would like to request the others, if you can just confirm that you support, that will make things easier for us, but I will not prevent you from making a short statement if you really want to. So I'll call you briefly, but don't feel like you have to make that statement. But before we proceed, I just feel I need to ask this very important question. A few senators mentioned it in passing, but I wanted to hear it from the resource person. And Attorney Estrada did mention that historically, and this question is for BIR, so BIR, be ready with your answer. Historically, and I think you mentioned the 60s, you have been paying the rate of 10%. So may I ask BIR if in fact that is the case, that all the educational institutions have been paying the 10%? Because I actually had different figures, so I just want to be clear, because the report, that the info I had when I was defending on this on the floor is different. So BIR, can you please clarify, do all the educational institutions pay the 10% rate? Or are there some that have been paying 30% and now 25% under CREATE? Are there some that are exempt? Let's just clarify that for the record. DOF?
Yes, Your Honor. Good afternoon again. Per our records, Your Honor, there are educational institutions that are paying 30% rate, and also there are those that are paying 10%, Your Honor.
And who are those paying the 30% and who are those paying the 10%? I mean, not the names, but are they classified under certain category?
Under the we have a basic code for private educational services, Your Honor, and there are those described or classified as private preschool education, private elementary education, private general secondary education. And these institutions, there are those paying 10% and there are those paying 30%, Your Honor.
Sorry, yeah, go ahead. What is the distinction? Who are those who are paying 30 and who are those who are paying 10? What was the basis for that different rate?
If the educational institution, Your Honor, is not a non-stop, non-profit educational institutions, then their income should be subject to the regular rate of 30%. And if it is a non-stop, non-profit educational institution and their unrelated activities do not exceed, their income from unrelated activities do not exceed 50%, Your Honor, then they will be entitled to the preferential rate of 10% under Section 27B, Your Honor. So there may be educational institutions that are not non-profit, non-stock non-profit, that also subject to 30% if their activity, unrelated activity exceeds 50%. Otherwise, they are entitled to the preferential rate of 10%, Your Honor.
Okay, thank you for that. I
Madam.
just wanted to spread that into the record. Yes, I'll call whoever is wanting clarification, but I just wanted to spread that into the record precisely, and it's you, no, Attorney Estrados, raising your hand, because nga, there is this statement made by Cocopea that historically they've all been paying a preferential rate. But the data I have from DOF is that, in fact, 30%, 61% of our private institutions are paying the 30%, and only 38% are paying the 10%. So my understanding, and correct me if I'm wrong, is that when we say that DOF suddenly imposed a higher rate, well, in fact, there was a bigger chunk of those who were paying that higher rate historically. So I'm saying that that is the information that I have. On that note, kindly clarify, you're raising your hand, no, Attorney Estrada?
Yes, thank you, Madam Chair.
Did you want to say something?
Yes, Madam Chair. We just would like to clarify that that statement that historically we are just subject to the 10% preferential tax rate, because that's the general rule. And for us, there are only two types of educational institutions: the proprietary educational institutions subject to 10% preferential tax rate under Section 27B of the tax code, and the non-stock non-profit educational institutions that are already exempt by the Constitution and also under Section 30 of the tax code. Now, this doesn't necessarily mean that there are no proprietary education institutions that may be subject to the 30%, because Section 27B itself provides that when the income from unrelated activities of these proprietary education institutions exceed 50% of their gross revenue, they are actually subject to the 30%. But other than that, as a matter of exception, we stand by our position that it has been 10%, no, all this time, as a matter of law and as a matter of practice. Now, there's also a possibility, Your Honor, Madam Chair, that other entities which may be performing education, somewhat related function that are not technically schools. And so therefore they are not subject to the preferential tax rate. Because again, Section 27B is very clear. Only those offering formal education approved or authorized by DepEd, CHED, and TESDA are entitled. So may mga ganun din pong exceptions. But again, we also wanted to know sino po yung mga na-subject to 30% because insofar as our members are concerned, we have been subject to 10%. And assuming that there's data on that, with all due respect to BIR, that doesn't naman change the tax regime. And in fact, it only emphasizes the need to finally correct the erroneous tax rates being applied to them if they are indeed entitled under the existing laws. Salamat po.
Thank you. I understand what you're saying. May I ask BIR if they can support that classification of Attorney Estrada, or do you have a fundamental difference in that classification? Because my understanding from what he said is they only interpret it to have to be two classifications, the exempt and the 10%. However, in the record you gave me, there are 61% of educational institutions that fall under 30%. And he is now saying that that could be because of those who did not qualify for 10% because they exceeded that 50% threshold. Is that the reason in the 30%? I'm just looking historically. No, I mean, I'm happy to move forward and leave this at this point, but I just want to be sure that this hearing takes into consideration the very facts that the committee also had when we were looking at this on the floor. BIR, please.
Yes, Your Honor. From our records, Your Honor, from our database, what we gathered are this data from the private educational services under the PSIC code 811 to 8159. No? I will mention, Your Honor, the names of these educational institutions, the description of these educational institutions: private preschool education, private elementary education for children with special needs, private general secondary education, private secondary education for children with special needs, private technical and vocational secondary education, private technical and vocational secondary education for students with special needs, private technical and vocational post-secondary non-degree education, private higher education, private adult education, and other private education services, Your Honor. That's the education services, private education services that are paying taxes, either 10% or 30%, Your Honor.
But that list you gave us does not tell us whether they are paying the 30% because of the fact that they exceeded the 50% threshold, or because they are proprietary and profit. I don't know, diba? That's what I'm asking you nga. Anong distinction? You don't have it?
Yes, Your Honor. We have no data on that, Your Honor.
Madam Chair, may we ask a related question, Madam Chair?
Of course, sure.
Yeah, thank you, Madam Chair. I suspect that the application of the 25 or 30% corporate income tax to private schools stemmed from two decisions of the Supreme Court. This is the St. Luke's case in 2012 and the De La Salle University case in 2016. I'd like to inquire, Madam Chair, whether previous to these two cases, there was any imposition of a 30% or whatever the corporate income tax rate was since 1968, when these provisions or its predecessor prior to the NIRC being enacted in 1998. So we're looking at 1968 onwards. Between the period of 1968 to 2012 or 2016, when these two cases were decided, was the regular corporate income tax ever imposed on the private educational institutions? I suspect hindi eh. Kasi yun talaga ang history niya eh. And then these two cases just kind of muddled up the picture and are being relied upon by the BIR. And it is our position I think as lawyers, Madam Chair, you're aware that there's such a thing as ratio decidendi and obiter dictum. Apologies to the non-lawyers for the legalese, no? But when you say ratio decidendi, that is the very issue in the case that is being decided. And when you say obiter dictum, that is just dictum or remarks made by the court which do not relate to the point in issue. So, in my opinion, the mention of private educational institutions being subject to regular corporate income tax in these two cases is merely obiter dictum, Madam Chair. So anyway, with that, and therefore not legally binding in that sense, no? Not strictly speaking as legally binding, because it's just obiter dictum. So yun ang tanong ko sa BIR, Madam Chair, and the DOF, if they have data previous to the decisions in these two cases, which they are citing as their basis for the revenue regulation. No? With due respect to our BIR, who's working very hard to collect these revenues, we respectfully disagree with that legal interpretation, and I'd like to hear from some of our legal eagles, like Senator Frank and yourself, Madam Chair, among others. No, so yun lang po. Yun ang tingin natin dito.
Thank you for that, Senator Sani. I'll ask BIR to respond, but basically that's the history that I was trying to draw out from my line of questioning. Na saan nanggagaling itong position ng BIR na there is 61% that have been paying historically. So when is that history? Not to refix your question, because the position of COCOPEA is historically 10% or exemption lang sila. So you put it very clearly now. BIR, can you respond to that? Again, this will just form part of our, we can move forward in any way we want because this is a new bill. But I think it's a good legal exercise for all of us. BIR, please.
Your Honor, yung data po namin na nag-gather is from 2016 to 2020, so for 5 years. But beyond 2016 or prior to 2016, wala po kami taong data. Pwede po namin pa-extract if it is available sa database. But we just want to point out that when the Supreme Court issued the decision in CIR versus St. Luke's in 2012, the BIR issued Revenue Memorandum Circular 67-2012. Basically reiterating the tax treatment of the application of Section 27B in relation to Section 30 of the National Internal Revenue Code. That was in 2012, Your Honor, as early as 2012.
So, to the best of
Yun
your
ang point
knowledge,
natin, Madam Chair. I don't think previous to 2012 there was any doubt on this provision, because if you look at St. Luke's, that's a hospital. They're talking about a hospital. It's not a private educational institution. And then if you look at the LaSalle case, which was decided in 2016, again, it's not a proprietary educational institution that calls for the application of Section 27B, which is being discussed. It is a non-stock, non-profit educational institution, which calls for the application of the constitutional provision as well as Section 30 of the tax code. That's why yun ang point ko na it's not the ratio decidendi of the case. It's just merely obiter dictum, Madam Chair, to reiterate. No?
Actually, that was my appreciation also, that it was obiter dictum. However, that seems to be the basis of BIR. That's what I was trying to elicit. Na,
Yes.
Even if lawyers would consider it obiter, apparently that was the basis of BIR. Can you confirm that, Associate Commissioner, Assistant Commissioner? Can you confirm that? That was the basis. Kasi ano pa ba, di ba? Yun ang intindi ko lang eh. Yun ang basis nun eh. Well, at least in the I'm not sure if there was a formal position paper at some point, but in the briefings I had with my staff, that's what they're pointing to. That was the turning point. Anyway, before I give you the floor to answer, let's call on Senator Drilon and then Attorney Estrada and then BIR. Maybe you can give your position. Then we'll just move on. No? This is a new bill, but it may help kasi in our understanding of the whole thing. So go ahead, Senator Drilon.
Thank you very much, Madam Chair. I'd like to ask point blank the DOF and the BIR. They are saying that they are in support of this measure, and the measure will precisely correct the erroneous interpretation in BIR Regulation 5-2021. Since they are in support of this measure, should they not repeal this regulation that they have issued? Because that is the purpose of the of Senate Bill 2272. If they're saying they're in favor of 2272, why don't they take the initiative of repealing or recalling the revenue regulation that they issued? Can I have a response?
Yeah, I would like to hear that, because then I can move on to the other tax measures and we can end this hearing.
We can all go home.
Yep.
Oh, pwede na tayong umuwi. Total, sinabi, pabor kayo dito eh. Eh kung pabor po kayo doon sa Senate Bill 2272, which precisely would try to correct BIR Regulation 2027, we will save a lot of effort and anxiety if you just repeal this, recall this revenue regulation. Because you appear to agree anyway with the position of Senator Angara and the 10 other or so co-authors. Can we have a response from Asek Napawu?
Yes, Honorable Senator, Madam Chair. From what I understand from the principal or the Secretary of Finance, we will be supporting this measure to clarify and correct the seemingly different interpretation on the matter. But we are of the position that this should be prospectively applied, considering that there was also an interpretation of the court in regard to the provisions of Section 27D as implementing or enabling the constitutional provision under Article 14, Section 4, A and B, Madam Chair.
Well, yeah, I was just asking that question because you were very straightforward. You said that the DOF is not against the measure. And then you were followed by the BIR saying that they support the measure. If that is so, then there should be no need for this measure, which is designed precisely to correct what, in our view of Senator Angara or the rest of us, is an incorrect interpretation of the Internal Revenue Code, Section 27B. So that is why I'm asking the question. If you're in support, why don't you recall or and rescind Revenue Regulation 2021?
Yeah. Go ahead, Asik.
Yeah. We also understand that the Supreme Court had issued on the matter.
Regardless of what the Supreme Court says, you as an implementing agency and we, the policymaker, have a say on this. If we're saying that the revenue regulation is not correct because you're willing to support Senate Bill 2272, which seeks to correct revenue regulation 2021, why can you not recall this revenue regulation? So that we can remove all the anxiety and the time of the committee and the Senate will no longer be spent on a matter which you are in concurrence anyway and which you can do something about.
Your Honor, from what I have understand from the message of the Secretary of Finance,
I can hardly understand you.
I'm sorry, Your Honor. The position of the Secretary of Finance was that it would be perhaps better that a legislation will correct
Yes.
the seemingly different, this bill should,
Yes.
however, be passed in order to really clarify the position.
We can
considering that-
still, Mr. Madam Chair, we can still do the legislation. But in the meantime, can you withdraw this regulation? So that there is no sword of Damocles hanging over the educational institutions. Since, we will proceed with with this measure if that is what you feel is needed. But in the meantime, can you withdraw? Can you direct the BIR to withdraw this revenue regulation?
From what I've understand from the last position of the DOF, Your Honor, the perhaps the proper remedy would be to for the enactment of the law and that prospectively applied.
I don't. Firstly, let me emphasize, Madam Chair, that Senate Bill 2272 is not an amendatory law. We are not amending anything. What Senate Bill 2272 seeks only to clarify what, because of the doubt thrown by the revenue regulation, and also, as may be pointed out, by an obiter in the decisions of the Supreme Court. So it is within the prerogative of the Congress to clarify the intent, especially in this case. We feel strongly that the interpretation and the BIR regulation is improper. And you yourself seem to agree that it is a correct interpretation of the law, because you said you're in favor of Senate Bill 2272. We will still continue to consider this measure, to put it all once and for all, to remove all the doubts and to overcome whatever obiter the Supreme Court may have mistakenly enunciated in the two cases mentioned. But in the meantime, what we're asking you is to remove the uncertainty, especially that our educational institutions are suffering from the effects of the pandemic. If you can give them immediate relief and remove their anxiety by repealing the revenue regulation, which you have admitted is contrary to the intent of the law, because you're in support of Senate Bill 2272. Asek Napao.
Madam Chair, with the indulgence of the minority leader.
On this point, can we? It's on this point.
On
As long
this
as it's on
point?
this point, yes, please.
Yes,
Go ahead.
on this point, Madam Chair. Thank you, Madam Chair, and thank you to the minority leader. Just in support of this very line of questioning and advocacy of the minority leader, and to stress the urgency of what he is asking the DOF to do. Because the strongest impact of a correct action is if it is done with the right timing. The minority leader is asking the DOF to do the right thing now and to prevent harm now by withdrawing that revenue regulation precisely before this new school year starts. So thank you, Madam Chair, and thank you to the minority leader.
Sige. If I may just make a quick comment before BIR responds. Sorry, before DOF and then BIR, if DOF has something further. I get the impression by asking the Senate to do this, mas madali ba kami kausap kesa sa BIR? Kasi, honestly, it's my impression, because as I said, I'm known to some of you, but known to others. I've been going through this for various provisions, and sabihin ng DOF sa akin, okay na yan, tapos iba pa rin lalabas ng BIR, tapos sabihin ng DOF, binawi na, tapos ilalabas pa rin. So baka yun yung point. Asik.
Yeah, Madam Chair, in the create, what was only changed was the rate. So since there was a Supreme Court interpretation on the matter way back in 2012 and 2016, then that interpretation stands with respect to the unchanged provision of the Section 27D, which we only, the create bill only changed the rate. So I think on the matter on whether the Supreme Court interpretation is really an overturned dictum, that should also be for the Supreme Court to say. And I think that route, that's the reason why we are supportive of this bill, even at the House version and also this present version of the Senate, is that we think that going through the having the court interpret again or withdraw its interpretation.
Yes.
That 2012 and 2016, that will be a longer route. And that also, Madam Chair, the filing of the IPR for the schools will still be in April 2022. So there is still, I think, enough time for passing this measure and have it in effect for the year 2021, Madam Chair.
Yes, Madam Chair, I have not heard anything which would justify or rationalize the refusal of the good Assistant Secretary to withdraw this erroneous revenue regulation. Madam Chair, you know, the two cases are cited by the good Assistant Secretary to support the proposition that this regulation is based on the Supreme Court decision. Madam Chair, let me point out that the St. Luke's case was decided in 2012. The LaSalle case was decided in 2016. So if these are really the basis for this revenue regulation, bakit ngayon lang? Bakit noon pa? Hindi nyo ginawa kaagad? What is clear is that you thought that you could take advantage of the passage of create and justify this erroneous revenue regulation on the basis of the amendment that we introduced, which has nothing to do with whether or not it is a for-profit or non-profit education institution. It does not change. I would repeat, it did not change anything. It only changed the rate. But you took advantage of that to issue this erroneous regulation, and now you're saying you are supporting this bill. I reiterate, why can you not withdraw this revenue regulation to remove the anxiety from our educational institutions of being subjected to an unreasonable rate, which is uncalled for?
Madam Chair, if with indulgence of the majority, I'll keep it short with the indulgence of the minority leader, Madam Chair. I suspect the position of the BIR and the DOF is a practical one, because if they withdraw it, it might be seen as an acquiescence to the interpretation, and they would have to refund everything that's been paid in the past. Yun lang yun eh. Ganun kasimple yun, Madam Chair, di ba? Kasi kung ganun, i-refund nila. Di problema yun para sa kanila. Saan sila kukuha ng pera? Hirap na tayo kumulekta. So yun na lang yun. I think it's a very practical reason why they want. I think we have to come to if we want this to be settled quickly, we have to come to an agreement that whether we want it prospective, retroactive, kasi mahirap yung ganun. Then we'll be, or leave it to the courts with respect to the current tax liabilities, and then going forward we adopt that position. But yun, tingin ko yan yun.
Attorney Ana Abad was raising her hand. Senator Gilon, go ahead. Did you want to say something first? Go ahead. Senator Gilon and then Attorney Ada Abad.
Well, we recognize probably that's a concern of the BIR, but we can commit to the good secretary that we will include a special provision in Senate Bill 2272 that it shall be prospective in effect, so that the BIR will not be subjected to claims for refund. But that does not invalidate our request that the regulation should be immediately suspended at the very least. At the very least, if not revoked, at the very least suspended, so that there is no fear that they could be hit, that their educational institutions could be hit with something. If it can be suspended now, and we can, I think I can speak for myself in the opposition that we will support this bill, and therefore the passage would be no problem in the Senate at the very least. And so, if with the assurance that we can clarify it along the lines that the BIR has suggested and the DOF has suggested, but in the meantime, suspend the implementation of that of the revenue regulation. How does that sound to the representative from the DOF, Madam Chair? Can we have a respond to that? If they don't want to repeal it, then suspend the implementation.
Go ahead, please.
Perhaps, Madam Chair, since the previous position of the DOF principals of the DOF secretary is to support the passage of the measure without mentioning that the existing regulations, which is Revenue Regulations 5-2021, will be suspended. Perhaps on that note, we may have to get back on our principals and get guidance in the matter. But as mentioned, the position that was the last position was that it should stay at the moment, and that.
So when can you inform the committee on this question? When can the committee, Mr. Assistant Secretary, expect a response from the DOF insofar as this particular request that the implementation of BIR Regulation 2021 be suspended?
Madam Chair, Honorable Senator, we will have to discuss first with our
Yes, we know. We know.
Perhaps by next week or when the time when our secretary will be coming back.
So yes, can we have a week for the good secretary to inform the committee of the suspension or continued implementation of this regulation?
Yes, we will apprise the committee of Ways and Means on that matter.
Thank you. Yes, that's all.
You still want to take the floor, Attorney Ida?
Yes, thank you very much, Madam Chair. It's only to stress the fact that we did try to exhaust all administrative remedies. We had even sent the DOF and the BIR 6 letters over the course of 2 months. Unfortunately, we had been met with a dead end. That's why we had to go through this route of requesting the good senators to at least try to come up with a clarificatory bill. But as we said, this is not really a clarification, but the fact of the matter remains that we have enjoyed this 10% preferential tax treatment since 1968, and a historical study would reveal that to be the intention behind the Congress to give the schools such support in view of the public good that it helps the government in its duty to provide quality education for all. We really would appreciate, however, if the DOF and the BIR would suspend at the very least the implementation of this Revenue Regulation 05-2021, because we have had reports that the BIR is already trying to impose a 25% tax on some of our member schools. So it really would be appreciated if the DOF and the BIR would do so at the soonest possible time, especially that school will soon be starting in a month. Maraming salamat po.
Tama yun.
Attorney Estrada.
Yes, Madam Chair, thank you very much. I just would like to go back to the question on earlier of Senator Sani, responded to by the BIR on whether there was a change in the tax regime prior to 2012 and even after because of the Supreme Court case. While there was a reference to an RMC, Madam Chair, there was actually no revenue regulation issued as expressed as Revenue Regulation 5-2021. Even after the 2012 St. Luke's case. The RMC is a circular that's internal to BIR. It could not have that binding effect on us, the regulated. Because insofar as we are concerned, we have been subject consistently to that 10%. And it was only the Revenue Regulation 5-2021 that effectively and expressly says it is being withdrawn. So that's why it has an effect on our call that there is in fact no change and there is no prospective or retroactive application because there is no change, and that if there will be an understanding, Madam Chair, Your Honors, on the no refund, we are equally concerned on the no assessment on deficiencies, because if we say the cut-off will be from the enactment of the law, on the prior years from 2012 until the law is passed, we also have that fear that the BIR will go after the proprietary education institutions on the old rate because at that time it was a valid rate. And so therefore that is our concern. In fact, I'd like to support the manifestation of Attorney Ada that in fact there are three at least educational institutions from different regions that went to us and asked for help because they're now being asked to explain by regional BIR offices their basis on why they were paying only 10% for the longest time. They were being asked a tax ruling in the light of the discussions now that the position of the BIR is that the proprietary educational institutions have never been intended by law to be entitled to the preferential tax rate. So we strongly join the call, with all due respect of the committee, to suspend, especially because of the urgency. We are entering a very critical period, Madam Chair. The school opening will be by July or August, and the schools have not decided yet whether they can survive, whether they can sustain. And we are also concerned about parents, about students now asking us on what would be the decision on whether to continue in the ensuing semester and school year. Maraming salamat po.
Yes.
Okay. Senator Gilon, did you want to say something?
Yes. Well, the urgency is brought about by the fact that schools are going to open. Look, I think it is natural to assume that the schools will pass on this tax to the students. It's reasonable. I mean, and you cannot blame them for that. They are already suffering from the pandemic. Now there's an interpretation that will increase their taxes tremendously, 150%, whatever. And they have to decide by the opening of the school year how to handle this, given the fact that the tuition fees will be paid at that time. So there is urgency in this, Madam Chair. We will not be able to debate on this on the floor until the first week of August at the earliest. And that is why I think it is reasonable to us to request that the implementation of 2021 be suspended until we can come up with something that is correct. As I repeat, this is not an amendatory law, because if you say a mandatory law, you are accepting that the previous practices were consistent with the law. No, this is a law which seeks to clarify, and in fact, even if it is an obiter in the expressed by the Supreme Court, we will correct that erroneous interpretation in our view by passing this measure. So, with more reason for the DOF and the BIR to suspend this in the meantime. If the courts, I could assume that this is in the courts, if they subsequently find it otherwise, then that's how it goes. That's how the ruling. But in the meantime, pwede po ba, and I will hold, Madam Chair, with your permission, our good friends from the BIR, that within 1 week, they'll tell us whether or not they can suspend this implementation, at least while we are debating on this measure.
Yes. That's very clear, no? But as the chair, I'll now formalize that request of Senator Rilon that more or less in a week's time, we get feedback from you on the position of DOF and BIR, so that should give you enough time to talk to the secretary about this. And then you can relay it to us, and then we'll take it from there. So on that note, I want to acknowledge the other resource persons who were here. I think you will agree with me that there's no need for everyone to make a statement, as we have, I think, thoroughly discussed this. Your statement on record naman, no? But I'd like to acknowledge their presence. Catholic Educational Association of the Philippines, Philippine Association of Private Schools, Colleges, and University, PAPSCU, Association of Christian Schools, Colleges, and University, ACSCU. Actually, I don't know if they're here. My staff says waiting for confirmation. TechVox School Association of the Philippines, National Alliance of Private Schools in the Philippines, Davao Association of Colleges and Universities Network, Cebu School Athletic Foundations, Inc., and Bicol Association of Private School, Colleges, and Universities. We also have tax practitioners Mata Perez Tamayo and Francisco, and IMAP is also present. So, okay, sorry, Ched, yes, Ched.
Yes, Madam Chair, I would just like to manifest for the record that the Commission on Higher Education fully supports the passage of Senate Bill number 2272 and supports also the position of the COCOPEA on this matter. We have submitted the signed position paper already to the committee this morning. Thank you very much.
Okay. Miss Uni Marie Perez, you are representing what group?
Mata Perez Tamayo and Francisco, Your Honor.
Okay.
Good afternoon, Your Honor. And I'm a practitioner, and I wrote an article about this way back in May. I'm thankful for the invitation. I'm just here to express my support to the bill, and that I concur with the Honorable Senator that this is a clarificatory bill and not an amendment. So there should be no issue on retroactive or non-retroactivity, because this should be retroactive if it's just clarificatory. There is legislative basis for the 10% application, as espoused and discussed already by Attorney Abad and Attorney Estrada. We support the measure, and we believe it should be retroactively applied.
Thank you. That's something that I would like to postpone for the next hearing, because the position of DOF, as far as I know, supports the Senator Sani bill, which is what we're hearing, which is different in wording from the House bill, which very specifically says that it is retroactive. So the Senate bill does not have that provision, and that is the position relayed to me by the DOF. So just put that on record.
Thank you, Madam Chair.
All right. So at this point, dear colleagues, if no one else has anything else to say, then we will suspend the hearing until further notice, roughly in about a week. If I hear from them, maybe we can just go into a quick caucus if it's easy enough. And if there's a need to convene again in the hearing, then I will send the appropriate notices. But I will definitely keep you posted within a week's time, regardless of what kind of information I receive from DOF and BIR. Okay, so this hearing is officially suspended until further notice. Thank you very much to everyone who came and participated. Thank you, dear colleagues, for joining me in this hearing. It's always nice to see you and hear everyone's input. So have a good afternoon. You can go back to work pa, maaga pa.
Maraming salamat po.
Stay safe.
Thank you, Chair Pia. Thank you.
Thank you very much.
Thank you very
Thank you.
much.